Thank you for joining us today to talk about being served with a subpoena. I'm Laura Krause from Crest Insurance Services, a Gallagher Affinity division. Today, we welcome attorney Catherine Holbert. Catherine has been defending real estate professionals for more than 15 years and is a very active member of the Crest Real Estate Defense Council panel. Along with Catherine, we have Dave Miller, Regional Vice President with Fidelity National Home Warranty. Dave manages the Crest Advantage Home Warranty Plan, which ties in nicely with the Crest E&O insurance policy. We have a lot to cover, so Dave, I'll hand it off to you and let you get started.
Laura, thanks so much for having us. And Catherine, thanks for joining us again.
Good morning. How are you?
We're fantastic. We are so excited about these risk management webinars because we love, and I speak for Crest on this, that we love just giving the risk management to all of the real estate professionals in Nevada. And you are just a huge asset and storyteller and somebody that is on the front line with E&O lawsuits and just gave such great advice on how to keep Crest's real estate professionals that they insure out of trouble. And today it sounds like we're going to be talking about subpoenas.
Yes, we are.
Oh.
And they are an interesting legal tool that realtors may not be completely understand what they are and what they're for and what they do.
Well, and I don't know a lot about them either. So I'm really interested in this call. So let's start from the basics here. What exactly is a subpoena and why would a real estate agent being served with one?
A subpoena is basically a court order ordering somebody to do something, to either appear or to produce documents, or very frequently do both together. A lot of times it will start with just give us your documents. Of course, for real estate agents, they're usually seeking transaction file or property management file or something like that. And then they can also say, we also want you to appear and talk about these documents. That might come at the same time. They might review the documents and then after looking at them say, hey, I want you to talk to me about this, and then you'll get actually a second subpoena. But you have to do something. If you get a subpoena, you have to take an action. You can't just like set it on your desk, set it aside, ignore it. And of course, you've got to do it by a specific date, which is contained within the subpoena.
Great. We'll talk about the timeliness of those and how maybe somebody shouldn't do something on their own and getting an attorney. But let's get right into it and just go through some of the do's and don'ts of subpoenas, because that's where you're seeing still issues with agents getting into lawsuits.
Right. And of course, the thing is, obviously when it comes to the agent, they understand they have to do something, but they might not know exactly what they have to do. They might not know why they're being requested. There's a variety of reasons why, because these are third-party subpoenas. If you're being subpoenaed because you're already involved in the lawsuit, that's a different issue. It goes to your attorney. That's not it. This is a subpoena that you get served with for a lawsuit that is going on between other people that you are not involved with. So your number one main goal as a realtor in that situation is to stay out of the litigation. You definitely do not want to do anything or produce anything or say anything that is going to get you involved. And primarily, whatever attorney serves you with the subpoena, they are looking for information to support their client's case. However, that attorney and any other attorneys that are involved in the lawsuit are also going to be keeping an eye out for any possible way they can bring you involved in the lawsuit. Because, if from the plaintiff's perspective, if they have one more party that they might be able to get money from, great. From the defendant's perspective, if they have one more party that they might be able to spread the liability among, great. So even though you're not currently a party, when you get a subpoena, that doesn't mean you won't later become a party. And in fact, that is definitely, if not the primary goal of the subpoena, one of the goals of the subpoena is to find a way to bring you involved in the lawsuit. And so don't think you're going to handle it on your own. Just think this is no big deal. I'm just going to send the documents in. I'll just appear at testimony. I'll tell the truth. It's not that they don't want the truth, but they want their version of the truth. And you don't ever want to just show up to a deposition on your own.
Sure. And is this sometimes when a plaintiff's attorney is a little bit upset and they're just, we're just going to name everybody? Is this kind of one of those situations where they will file for the subpoenas to try to drag other parties in?
Well, not necessarily. If they truly think at the beginning of the lawsuit, when they actually file the complaint, that they've got a cause of action against you as a real estate agent, they'll name you then.
Okay.
So this is more like, we're not seeing anything yet, but there might be something there. We definitely want your transaction file. And if we see something in the transaction file, we'll bring you in. But before they get to, they've already essentially made an analysis. They know who you are. They know you're involved. And they have already made a preliminary analysis that they don't want to name you as a party. But they still want your documents. They are still involved for a reason, generally speaking. I've also seen subpoenas, though, for something that like truly doesn't have anything to do with you or your transaction. One example that comes to mind is this property management company was served with a subpoena from the Nevada Division of Welfare. And they were concerned that maybe the tenant had committed welfare fraud. And so they wanted the documents that the property manager had on, application and rent and whatnot. But there was never any possibility really that realtor would become involved in the dispute between the tenant and the welfare division. And so, the other thing is a lot of times the people that do these subpoenas, the attorneys that draft these subpoenas, are not real estate attorneys. So they don't truly understand the documents that the realtors do and don't have. In that particular case, the subpoena was not really well drafted at all, because she just did not understand the documents we had. So I called the attorney for the state and I said, look, I've also got this, which ones of these documents that you didn't ask for that we have do you want? And we were very cooperative, and we gave her everything that she might possibly want and gave it to her, in the form that she wanted it, and we're extremely cooperative. If I'm dealing with an attorney in a situation where the agent might possibly get involved in a lawsuit, I'm only giving him exactly what he's asking for. If he doesn't ask the right question or ask for the right document, we're not volunteering anything. We're not necessarily being uncooperative, but we're not going out of our way to cooperate with somebody that could potentially sue us and is actually seeking to sue us, if that makes sense.
No, it makes perfect sense. Only answer what you're being asked. That's because the more you tell, it could open up other avenues, I'm sure, for them to
right. And of course,
pick at.
the natural inclination, which especially for realtors, is always let's be helpful. And if I just am honest and give them everything that I have, I'm not going to get sued. Well, unfortunately, it's exactly the opposite.
Right. In your risk management update that's on the CREST website, by the way, for the state of Nevada and subpoenas, you talk about that subpoenas require you to do one of the two, either appear or produce documents. Let's talk about appearing. What are some things that that agents and real estate professionals should know when they are appearing in person? And then we'll talk about the documents later.
Well, the appearance, first of all, just don't do it on your own. When you appear, you're usually, it can be for a trial testimony, it can be at an arbitration, it can be at a mediation. So, somebody just getting served with a subpoena might not even know that, because it just says you have to show up at this time and this place and give testimony regarding something, your transaction file or the real property located at a specific address. And they might not know, but that's why they need to get an attorney involved that can figure out what is the purpose of this. What is the underlying litigation going on? What is the underlying dispute? How does this play in? Because all of that matters for preparation. And, preparation before deposition testimony or trial testimony is a fairly lengthy process between an attorney and their client, and it's very important. You don't need to, you should never just walk in and sit down and say, hey, I'm just going to answer your questions and tell the truth.
Right. So obviously,
for a variety of reasons. Not only does it not in your best interest, but frankly, it doesn't necessarily serve the other side either,
Right.
Because then they have to do your depo prep for you, basically.
Well, I'm hearing just don't show up and appear, have a game plan and have somebody in your corner. Obviously, that's hopefully there with you.
Absolutely, absolutely. And, a lot of times, whatever insurance policy you have has got subpoena coverage, because it is very much considered a part of risk management. And they know that if they help you respond to the subpoenas correctly, that it reduces your chances of being involved in the litigation. So, I mean, obviously you have to check your own policy always and see what's there. But check, take the effort and check, do I have coverage for this?
Absolutely. And I think that the insured should handle it the same way. If they get a demand for money or services, they're probably going to call the risk management hotline at Crest, or actually just file it to the claims department, because what they think is actually a claim is happening. But I think that if they're being served with a subpoena, the first call they make is probably to Crest, the E&O carrier, or the E&O program,
Absolutely.
to make sure that they have somebody in their corner.
Absolutely. And like I said, if for whatever reason they don't have it covered, it's still worth paying their own attorney to handle it, rather than trying to do it on their own, because it could literally and very frequently make the difference between being a third party witness and a defendant.
Right. Well, let's be honest. Real estate professionals are not experts in subpoenas. Attorneys are. So why would they not
Absolutely.
want somebody who's specific to that to help them? Let's talk about the documentation. Now, you have said for years, documentation, documentation, documentation. Maybe some of these agents aren't, they don't take as much information and save it as they should. Where would those agents be in trouble in a situation like this, where they would have to provide documents?
Again, it comes into play of, what exactly are they asking for versus what you have. And another very interesting issue that I personally have had for 20 years is, what is a transaction file? And it's not everybody has the same definition of that. Like frequently the Nevada Division of Real Estate, if there's a complaint, the first thing they do, because it's a broker's file, it's not the agent's file, it belongs to the broker. So usually the subpoenas will come in to the broker. And so if there's a complaint, the NRAD will send a letter to the broker and say, give me your transaction file. And the broker sends what they think is their transaction file. And yet oftentimes it does not include correspondence. It does not include photographs. And the Nevada Division of Real Estate's like, I asked you for your entire transaction file. And I've tried to explain to the division, there's no ill will there. They're not trying to hide anything. It's just that they keep it, literally it's a storage situation. They don't store the photographs and the correspondence in exactly the same electronic form and place as they do the rest of the transaction file. So oftentimes, if you don't specifically ask for the correspondence and the photographs, they don't get included in that transaction file. And again, that's a fine line of what, in a particular case, sometimes I might call and say, hey, you didn't necessarily ask for documents, but I've got them, or photographs. Do you want the photographs? And sometimes I'll say, they didn't ask for them, they're not getting them.
Right.
But but not everybody even defines transaction file the same way. But usually that's all that's asked for on the subpoena is send us your transaction file.
That's great. You mentioned once the attorney is on file on your risk management update, you have 7, I think, valuable bullet points of things that are going to happen from there. And number one, you mentioned about the attorney looking at the subpoena just to make sure that it was proper. What would make it improper?
If they are not asking, if it's served to the wrong corporate entity, perhaps. If it is, there's a lot of big, Remax, EXP, there's like a ton of things. And maybe, yes, this was an EXP transaction, but not this particular broker or something like that. Or they just, they named the right person, but they didn't serve it properly. They didn't give you enough time to respond. They didn't, give you, there's a form of your rights and obligations. There's just some real procedural formatting issues that may or may not be correct. But to have an enforceable subpoena, it needs to be correct. Some of those, depending on what the circumstances would be again, and how likely I think the party would be involved, I would be like, they should have given you 14 days, they're only giving you 12, but I'm not going to make a big deal about that. Or I might say, we're making a big deal about it in this case.
Right, that makes sense. I mean, and again, it comes back to if it's not proper, you don't want the real estate professional giving them this information if maybe they shouldn't have. So just having that attorney is amazing. You mentioned in your document here too about how the attorney will speak to the other party's attorney. How important is it that real estate agents not get involved with talking to the other party's attorney?
Um, very, very. And it's easy for me to do this analysis with real estate agents because real estate agents talk to real estate agents, but that's it. And they don't want their clients talking directly to the other agent. It's exactly the same situation. If you're my client, and I'm talking to the other attorney, you don't talk to the other attorney, and you shouldn't start that. I mean, and just like, the real estate agents don't like to deal with sellers that are selling their own home. It's just much easier to deal with somebody else who's trained to do that job. And you don't speak the same language as the attorney does, and you're not gonna be able to, and you can't represent yourself. Really, nobody can effectively represent yourself, including that's why we hire real estate agents.
Right.
So just get the right professionals in and let them do it.
Well, and you mentioned here too that the attorney will prepare the real estate agent for the deposition. What are some things that the agent should know? What happens in a deposition, and how can an agent maybe answer too many questions that are inappropriate and get them in further trouble?
Well, a deposition is completely different than a conversation, and it's not necessarily a fact-finding mission. The attorney that's noticed the deposition has got a very clear goal that he wants to accomplish, which of course is to benefit his client. You are not his client. So he is not your friend. He is not helping you. Is he your enemy? Not necessarily at this point in time, but he's not, and what people don't understand is I've heard them say over and over again, I'll just sit down and tell my story. That's not even possible at a deposition. It's not like you sit down and the attorney says, okay, tell me your story. No, they ask very specific questions that you have to respond to. And you may not, what you think in your head is the most important thing that you say, you may never get the opportunity to say, because you don't just get to talk or say what you think you want to say or what you think is important. You have to respond to their questions. And I usually say, and of course, in conversation, you can anticipate what somebody may be asking and answer more than they actually ask. I always say never do that in a deposition. Whenever possible, answer their question with a yes or a no. And if there's a follow-up question, make them ask that. And that way you're not answering something that has not really been asked, or in a way that, and that's where you get down, like the thing that you might think is the most important to say to them might be the thing that gets you in trouble and gets you involved in the lawsuit, and you don't want to say that if they're not asking for it.
Well, it sounds like just having the attorney with you is a no-brainer process. And what's important, and you highlighted in your risk management update here, is that once you involve the attorney with you, it's good to keep them up to date on everything, because if this turns into now you getting sued instead of just being the third party witness, the attorney will be with you for that trial and already have knowledge of everything.
Absolutely. If it happens in Nevada with me, absolutely. I would, stay with you the whole way. And it's good. And the other thing I think maybe I forgot to mention on the document, the other very interesting thing about specifically real estate transaction documents and real estate transaction files is there is very often documents in your file that are not yours, very specifically including home inspection reports. If you're representing the seller and there was a notice of request for repairs, and so you ended up with a home inspection report in your file, you have that document, but it is not yours. It was purchased from the home inspector by the buyer, and you can't necessarily just turn that over, but you also can't just not turn it over. And that's where we get into raising the objections that may be necessary to the subpoena and getting a protective order from the court. Or sometimes, depending on what the issues are, if the home inspection report is going to be a huge red thing, red flag and a big part of the transaction and could potentially even bring in the home inspector. I want the home inspector to have a heads up on that. And I want to be able to tell, whoever sent us the subpoena, I've got a home inspection report. You've got to get it from the home inspector. And I'll tell you who that home inspector was, but you've got to go directly to them and get it. And sometimes they'll do that voluntarily. Sometimes we would actually have to get, a protective order from the court to say, if they want this document to belong to somebody else, they've got to get it from who it belongs to.
Well, it sounds like your risk management advice here is, subpoenas they're not terrible up front. I think some agents might overreact and think they're being sued, but ultimately they're just a third-party witness. But if they do these and react to these improperly, they could be dragged in as as a party of the lawsuit. So it sounds like what you're advising here is if you do these things right, you will stay as a third-party witness. And you even reference if you respond to these improperly, it's almost like selling your house on your own without a real estate professional. What's your comment there?
Right. Just don't do it. Just do not
Just don't do it.
Yeah. And then the other thing is it's not like I could even say, hey, here's this webinar. Here's like this list of rules that you should follow. And if you follow these rules, then you can do it yourself. Because every subpoena is different, just like every real estate transaction is different. And that's why you have to bring in the professional to do it, because, I might do something in one case and something totally different in another case, because the cases are different and the subpoenas are different and the situation's different.
Right. You have a couple of stories that you've shared with Laura and I in the past. You say that you hear all the time, it's no big deal. I'll just show up and tell the truth at this subpoena. What are your thoughts there?
Yeah, it can end very badly. Yeah. And like I said, unfortunately, people think, well, this is a justice system. It's all about justice. They just want me to tell my story. And like I was saying, that is absolutely not what is going to occur in a deposition. You don't just get to tell your story. They're not just really looking for the truth. They're looking for very specific facts and information. And they will want you to just say this one little thing and then, nothing else. And you are not in control of it at all. And if you don't understand the process and what is going on, you can very easily immediately become a party versus a third party witness.
Well, you also mentioned here, and I love this part, that sometimes when you're being, served with a subpoena or ordered with a subpoena, it's not always from a real estate attorney. Sometimes it's just from a regular attorney that's not a real estate attorney.
Right. Like I said, that one case was from the Nevada Division of Welfare Services that wanted a property management file. Sometimes it's a dispute. It's a domestic dispute, like a divorce even. But they want your transaction file because maybe somebody did something before they got married or while they were split or something like that. And one of the spouses was involved in a transaction and the other spouse didn't know about it. That is a frequent occurrence. Now, of course, you as a real estate agent are never going to become involved in the divorce action per se, but if you handled that transaction incorrectly, the other spouse could bring you in under a new lawsuit, which is even worse than becoming a party to the original thing, is to get involved in a whole new transaction, a whole new lawsuit because the one party decides you didn't handle the transaction right. So, I mean, there's all kinds of things. I think there was one that even like the MLS subpoenaed information from a real estate agent because somebody had sued like the MLS and they wanted some information. So it's not necessarily a big deal. A subpoena is a tool that legal professionals use to obtain information, whether it's testimony or documents or both. So that's all it is. It's a tool that's being used by a professional to get something that you got. But it's not as easy to respond to it as just say, okay, I'll give you what you asked for, because from the very beginning, you have to analyze what is it you're actually asking for, but what is it that I've got?
Right. And let's talk about that for a second, because some people could be that think they do nothing wrong as a real estate professional, could get a subpoena and just fly off the handle and be extremely negative and put a fence up and say, you know what, I'm not giving them anything. And so talk to us real quick about how it's just best to be cooperative with these, that'll help them down the road.
Well, it is, I would say, I mean, it's, you definitely don't want to ignore it. You definitely don't want to say, I'm not cooperating with that, I'm going to set it aside. But really, all you should do is call an attorney and give it to them. You know, even though you maybe could cooperate and maybe you could handle it correctly and give them everything that they need, it's going to take time away from you doing your real estate transactions. So don't even try to spend the time on this. If you get a subpoena, just your normal automatic first reaction is call your insurance, get an attorney involved, and let them handle it from there. Now, of course, your attorney is going to be, you know, wanting your file. And I go through it and I say, give me everything that you've got. I'll decide what we're going to produce and what we're not going to produce. You don't want to spend the time and effort, even if you think you know how to do that. Why would you spend your time on that? You know, it's not a money-making process for you. You know, go do what your job is. Stay in your lane and do what you need to do. But definitely you don't want to ignore it or to say, I'm not responding to this or anything like that. And don't be scared of it. You know, it's just a request for information. And you should have it, and, you know, and don't panic and say, hey, my file's not complete, and definitely don't try to complete your file. You know, you just, whatever it is, and we deal with it, and you just, you know, call your insurance and call an attorney and let them handle it with no stress to you or minimal stress to you.
Well, and you mentioned it's just a request for information. So I'm going to ask you a rhetorical question here. Should an agent then just think, I'm going to go ahead and just take care of this myself? I don't want to involve my real estate broker because maybe I had an issue last week that he or she was involved in, and I don't want to become that agent who is always in trouble. So should I just do this by myself?
Absolutely not. And that's the other interesting thing. Any document, you know, any request for the file should always be directed to the broker, because the transaction file belongs to the broker, whether they represent buyer or seller. It's a broker file. However, it's the agent, of course, that usually has got the specific information. So I have seen, and it's not at all uncommon for them to request the documents from the broker, but then say, you know, a different subpoena to the agent and say, we want the agent to talk about these documents. But if you just get the subpoena for the testimony and it just comes into an agent, absolutely, you've got to involve your broker immediately. You know, your broker's got to know that's going on. And of course, then, you know, the broker should, of course, call the insurance and call the attorney, but never as an agent say, I'm just going to handle this on my own. Because anything you do as an agent involves the broker and the brokerage. And they have to know everything that you're doing, including responding to subpoena.
The last question, I promise. We're talking about providing documentation. How long should a real estate professional keep a file together? I mean, even emails that could come back later. How long should they save these?
Well, you follow the Nevada law on that, 7 years. You keep your, you know, the broker, you know, and then, so if it's over that long, you know, you say, well, the division's, you know, commission only says I have to keep it for this long. I kept it for that long and it's gone now. But you just follow the you know, the Nevada rules on that from your industry, from whatever your industry is.
Perfect. Well, any other little nuggets for us before we move on to?
I think that'll do it.
Oh, that's great. Well, I'll tell you, that's such great information. Again, a copy of this risk management update is on the Crest Insurance website for the real estate professionals in Nevada. Catherine, always such a wealth of knowledge. And we know you're on the front line. So what you say is true and extremely helpful to the real estate professionals out there. So thanks for all the things that you do for everybody.
You are so very welcome, and always appreciate the opportunity to share. Thank you.
Thanks so much. Laura, back to you. Thanks so much for having us today.
Thank you.
Thanks to both of you. Always very informative. Excited to get this one out on the website. Again, as Dave said, it's on the Crest website. It's on the Claim Prevent blog page. So we'll see you next time.
Thank you.
Thank you. Bye-bye.